to authorize and direct the city attorney to settle all claims with Avery J. Townsend, to ratify the authority of the council president and council chief of staff to execute the settlement agreement to authorize the expenditure of $92.00 in the settlement of claims from the Department of Finance citywide account to Columbus City Council Fund and declared emergency. This ordinance is submitted to settle any and all claims related to Avery J. Townsend's employment with separation from the city of Columbus in the amount of $84,792. Prior to getting into more details of the subject matter of this piece of legislation, I want to just take a moment and address the timing of this coming before council. As we heard earlier from the city attorney, there is no standard timeline for these kinds of settlements. Here tonight, as I pointed out, we have settlements regarding events that transpired as far back as 2021. The event that gave rise to this settlement took place in the spring of this year. The first communication received by the city attorney regarding these claims arrived in June of this year. After several months of negotiations, the final terms and settlements were agreed to late last month. Tonight, we held an executive session to help speed the briefing process for members regarding the terms of the settlement, as it oftentimes will take weeks for the city attorney to set up briefings for 9 different council offices. In my nearly 7 years on this body, I believe this is the fastest I've seen a settlement move from a claim made against the city to the city attorney conducting a substantive investigation regarding those claims, to negotiations between the parties, briefing council members on the settlement, and bringing legislation forward before this body. As we discussed earlier, one of the ways in which a claim comes before us in which it will produce a settlement is a demand letter is sent by a potential plaintiff. In this case, that letter was sent directly to council members or directly to council, which was then transferred to the city attorney's office. And I want to start with some questions in light of a attempt at full transparency coming before the body here tonight. So that, again, demand letter was sent directly to council and then was transferred to the city attorney's office. General Counsel Baker Morse, could you review sort of the specific legal claims that this demand letter made in this case?
Yes, President Pro Tem. So the demand letter included claims of violations of the Family and Medical Leave Act, or FMLA, the Americans with Disability Act, discrimination under Title VII on the basis of disability and sex, and acts of retaliation during the former employee's employment with the city.
Thank you. I want to be very clear. We had a public speaker several weeks ago that made some allegations regarding that a settlement was being considered regarding issues of sexual harassment or other kind. Is there anything within that demand letter that speaks to any of the claims being sexual in nature?
No.
Thank you. What's the city's legal obligations under the Family Medical Leave Act?
So the Family and Medical Leave Act, generally speaking, affords individuals who are employees of a larger sized company organization with 12 weeks of unpaid leave when they are experiencing a serious health condition. That serious health condition can be a condition of their own as determined by their medical provider, and or if they are caring for an individual family member who is experiencing a serious health condition. They are entitled to notice of the ability to obtain FMLA leave, and they are entitled to designation of leave that they take as FMLA approved leave.
Thank you. Does the Family Medical Leave Act require someone on leave to be paid?
It does not.
In this instance, did the city continue to provide compensation or pay this employee?
It's my understanding that the city has a policy of allowing individuals to use any paid time off that they have available to supplement when they're on FMLA, and I believe that was the case in this instance.
In a situation where an employee is on FMLA leave, is it legally permitted for an employer to reach out to that employee while they're on leave? And if so, what are sort of the instances in which that would be permissible?
Yeah, sure. So it is permissible for an employer to reach out to an individual who's on leave. However, the employer must be careful not to be in any way, shape, or form inhibiting that individual's ability to take advantage of the benefits of the leave. They cannot obstruct the leave in any way or interfere with the taking of the leave. So as an example, if an individual is out on leave and the employer has a question, and maybe they went out on some emergency leave and they're looking for a particular file that they were working on, or a password in order to enter a particular piece of software, it's certainly permissible for an employer to reach out and ask those basic questions. The questions shouldn't devolve to the point where that individual feels like they're still working, for the employer. It's also permissible for an employer to reach out and inquire as to what time that individual, when that individual will be returning to work. Those kinds of reach outs should be de minimis. They should be handled by the HR department ideally, and they should be very much just for getting that essential information that the employer needs to continue the work of the employer.
Thank you, General Counsel. In this specific instance, were there city employees that reached out to this individual while they were on leave?
Yes.
And is that the main substance of the legal claims that are coming before this body tonight?
That is the essence of the claims.
Thank you. I know we have received a number of public records requests related to the settlement in recent weeks. It's also my understanding that those requests have not been fulfilled to date.
That's correct.
My understanding is that many of the documents that have been requested are not currently considered public documents under House Public Records Law. So, for example, that demand letter that we've talked about, why wouldn't that be considered a public record at this point?
So Ohio law within the public records law allows for trial preparation records, work product records, and attorney-client privilege communications to be protected as non-public records at various points throughout the course of a negotiation and/or a litigation. The reason behind that is to allow for the attorneys to be able to litigate their case in court and to potentially allow for settlement without it immediately becoming a public record that would make it challenging then to bring that case to settlement. However, once you do reach a final settlement, and if this were litigation, that would also include all your appeal rights. Once you reach a final settlement, a number of those documents will no longer be able to afford the protections of being a trial preparation record.
So in this instance, using, for example, that demand letter from the former employee's attorney, when would that be a public record that could be provided to those that have filed a request with counsel?
Once the matter is fully resolved and settled, which in this case, if this council should choose to pass this particular ordinance tonight, and if that is then executed by the mayor, at that point in time, there is a waiver of right of appeal, and so it would be final at that point in time, would be able to be released.
Thank you. Again, here in this instance, the demand letter specifically is the legal claims that are being made revolve around FMLA and leave. However, there are allegations in that letter regarding from the former employee that Councilman Remy, who was this former employee supervisor, was very difficult to work for. That he would regularly raise his voice. That there were other allegations regarding a poor work environment. Is that an accurate depiction of a portion of that demand letter?
Yes.
Thank you. Has the city admitted faults in this settlement?
Has the city admitted fault?
Has the city admitted fault?
No, it is not.
Thank you. Thank you, General Counsel. I want to pause and see if any of my council colleagues have any questions for the city attorney's office at this point. Seeing none, thank you, General Counsel. The allegations that have been made are troubling, and personally, it's very, very disappointed that this body is in this position tonight to pass a settlement with a former employee. Allow me to be clear. The workplace behavior that is described in this demand letter is not acceptable. And I don't think any member of this body believes that behavior was acceptable. No one should be subject to that kind of behavior in the workplace, let alone those that have raised their hand to serve the public. I believe Councilman Remy knows that and knows that this body expects our staff to be treated with dignity and respect, and will take the necessary actions to make sure that he does that in the future. The emergency action is being requested for this ordinance so that it can be moved forward quickly to effectuate the settlement. of the claims and to ensure the best interest of the city can move forward. Wanted to pause and see if any of my council colleagues have any questions or comments before I ask for a vote. Council
Mr.
President?
Chair, first of all, thank you for not just handling this settlement this evening, but for leading us through 5 difficult settlements. I think that's what you saw us going into executive session to discuss, to be briefed upon, so that we could move forward. As it is clear, the Public Safety and Criminal Justice Chair normally handles these settlements. But given Councilman Remy's role in the events of this settlement and his planned absence today, I asked Councilmember Dorrance to manage it. As you've all heard from the discussion from the President Pro Tem and from our City Attorney's Office, this settlement legally and technically is about issues pertaining to an employee's paid leave plans. And like many settlements that come before this body, the purpose of the settlement is not to neither to validate nor rebut specific claims, but rather to resolve the overall matter amicably. But as with many settlements, council members often want to know that the relevant department takes seriously the issues that the impacted employee or the resident has. We want to know how the city is working to reduce the likelihood of something like this ever happening again. This settlement is unusual because it pertains to a matter inside City Council. But I do not consider City Council to be above that same kind of questioning. If anything, the public should hold us, City Council, to an even higher standard. I certainly do. And so with this settlement, I have tried to role model the kind of transparency that people should expect when there are settlements involving any city department. We're not trying to sweep anything under the rug. In that spirit, I want to address that the employee also made other claims about Councilman Remy, who was their boss, that he was harsh, that he was disrespectful, and that he was a terrible manager. And I know that Councilman Remy can be direct and difficult to work with at times. Hell, he's raised his voice at me in the presence of others before when we've disagreed on things. So I want to tell my colleagues, I want to tell the public, and I want to tell the media and our staff who may be watching how we handle this. Before I was an elected official, I was a staffer here in City Hall. So I take this issue very seriously. I know firsthand that how you speak to someone matters, especially when you're in a position of authority. After the conversation with the staff member, I told Councilman Remy that that kind of behavior was unacceptable to me. I told Councilmember Remy that he would need to agree to management training and that I would not sign off on any permanent staff for him until he got professional help. He is in the process of that training now. He's had to work a lot harder without having a team to support him. But this event also showed me that there are gaps that exist in our own HR systems here at Council for managing and properly documenting personnel issues. And I've directed the Chief of Staff to fix them. We also now added a second staff member to the City Council HR team to balance the burden on the HR director and to work on training and culture within City Council. We all have a responsibility to make our employees feel valued and to make the City of Columbus a great place to work. Just one employee who leaves the city because they had a negative experience is one too many. I care about my colleague, Councilman Remy, as a person, and I believe he's a good man and a good legislator. But this is a moment of learning, not just for Remy, but for me and this council. It's a time for accountability for Councilmember Remy. Next January, I will ask my colleagues to reelect me as council president, and then I will make committee assignments. I will take many things into account when I make those decisions. In this situation, as well as other opportunities to move this council forward, will be at the front of my mind. Again, I want to thank the City Attorney's Office. I want to thank President Pro Tem Dorns, this is above and beyond what I have asked you to do in the past. I want to thank my colleagues. We spent almost an hour in executive session today learning about this situation, but others, and deliberating. And I'm grateful. I'm grateful for you. And we will continue to move forward together. Thank you.
Thank you, Council President. With that, I move for passage as emergency.
Clerk, please call the roll.
Bangston, Barosa de Padilla, Beatty, de Akauer, Dorns, Green, White, President Harden.
Passed.
Thank you. Council President, with your permission, I'd like to move to rules and policy.
Sure.
Thank you. There I have ordinance 2857-2025 to amend Chapter 2509 of the Columbus City Codes to enact Section 2509 to establish the requirement for emergency power supply when an electric motor-driven fire pump is installed within a structure. This ordinance establishes a proactive fire protection measure to ensure electric-driven fire pump has an emergency power supply in the event